I'm so glad to see these faces around us. I'm thinking about some of the coal ash families who have already driven to Nashville tonight because they want to go and be and hear what happens in the courtroom tomorrow. It's been so wrong and also so long and also so wrong in my heart, because Jacobs Engineering, which is the defendant in this case, they're the contractor, the general contractor that TVA hired to run this job. They're the ones who promised to TVA to keep things safe. Jacobs keeps losing specific battles in this case, but they are winning a war for delay. And we're getting close to 60 people who have died since the cleanup itself. The Phase 1 jury, after hearing all the evidence and hearing from experts in occupational disease, decided 3 crucial points. 1, Jacobs broke its promises to TVA that it was going to run a safe job. 2, Jacobs failed to exercise what we call reasonable care for safety at TVA. This is a duty it owed directly to the men and women working on that job site. The third thing the jury decided in the plaintiff's favor was that coal ash is indeed capable of causing the specific injuries that Kingston workers were complaining about in this lawsuit. Never yet have we made it into Phase 2 of this trial. So today, workers are still waiting for relief, even as the years tick by and more people keep dying. Jacobs has now come up with another theory about why the claims of Kingston workers are just not good enough. Jacobs now claims that a Tennessee statute called the Tennessee Silica Claims Priorities Act should be applied to the Kingston case. Back at the time of its passage, this Silica Claims statute was championed by the notorious American Legislative Exchange Council, or ALEC, a group known for its ultra-conservative, anti-worker, anti-environment, and pro-industry approach to pretty much everything. So it should come as no surprise that the Act puts many special restrictions on silica cases, making it more difficult for workers harmed by silica to get their claims heard, and making it look pretty attractive to an outfit like Jacobs. What the court eventually decides will have an immediate impact on some or all of the Kingston workers and their chances of getting to Phase 2. It will also become part of the general climate that surrounds and shapes how TVA and other utilities will handle coal ash going forward. So we all have a stake in this matter for our future. Because make no mistake, there will be coal ash in our future. Mountains of it. TVA has millions of tons of legacy coal ash stored at coal-burning steam plants all over Tennessee. As TVA continues to move away from coal, these facilities will one by one be closed or moved or redesigned for other fuels. And as that process unfolds, TVA will be deciding what to do with this residue of its coal-burning history and what risks it is satisfied to take with worker and community health. So, mindful of tomorrow's threat, here we are again. Many of us, this is not the first time we've stood in support of Kingston workers and their families. We call on TVA, on Jacobs Engineering, and on our Tennessee Supreme Court to do the right thing. We send out our strong best wishes, prayers, and solidarity to Kingston workers and their families, and we will not be moved.